Hello and welcome to another exciting episode of Inventor's Quick Tips. Today we're going to talk about preparing for an initial meeting with a patent attorney. Now, being prepared for this meeting is important because by being prepared, it can help give you a more effective patent application. It can help reduce the time required to prepare that application, and it can also possibly help reduce the costs required to file the patent application, or to prepare the patent application, rather. So, with that in mind, let's jump right to it. You want to be prepared to discuss your invention, and that includes providing a written description of a paragraph or more at least, and perhaps some drawings or sketches. In that, you want to include the background. What problem are you solving? What new features are you providing? You want to focus on what is novel about your approach. Why is the way you're doing it special as you believe it to be, or unique? And what are the important parts of your invention that you wish to protect? What are the things that make it commercially viable? What are the things that you don't want competitors to be able to do? Be prepared to bring that to the attention of the patent attorney. Have a list of what work has been done to date on this invention, and this can include designs, any detailed description about how to build or how to use the invention, prototypes. Prepare to give a list of what prototyping has been done, what have you built, what have you tested. If there's any photographs available, either have the photographs handy or at least let the patent attorney know that photographs exist. And think about any alternative ways to do this, any alternative materials, alternative techniques that might also be used to make or use this invention. And that information can also be included in your patent application to help make it more broad and cover more possibilities. Inventorship is a patent term for the people that contributed to the invention. So you want to identify who has contributed to the conception and design of your idea. And the key reason for this is that incorrect inventorship can lead to patent invalidation. So you certainly don't want to do all this work, get a patent to issue, have it be for something that's commercially important, only to have it invalidated by someone that you're trying to use the patent against due to incorrect inventorship. So basically, the bottom line is you want to make sure that on the patent, the proper inventors are listed. And investors are not necessarily inventors. So just because somebody, put up the money for the work to be done doesn't mean that they are an inventor. Bottom line is be prepared to explain who did what in the development of your invention and be able to provide the patent attorney the list of the inventors for your invention. Next thing we want to talk about is schedule constraints. And to do this, we're going to talk about a few circumstances. The first one is, was your idea disclosed to anyone? And if so, who, when, and under what circumstances? Because a public disclosure under certain conditions can technically prevent you from getting a patent on your invention. So hopefully that's not the case for you. But basically, in general, it's better if you can file your patent application before any form of public disclosure. But if you did do a public disclosure, in certain cases you have up to 1 year to file an application. But in general, it's better to file an application sooner rather than later. Was your invention offered for sale? If so, when? And notify your patent attorney about that. Are you planning to disclose your idea to anyone? So, for example, presenting it at a conference or a trade show. If so, when? So in a scenario where, let's say you are going to a trade show in 3 weeks and you're planning to give a presentation or talk on your invention or your idea, you want to let your patent attorney know that so that there's a chance that you can get something on file before you go to that trade show. Was a provisional patent application filed on this idea? And if so, when? So, for example, if you filed a provisional patent application, then you want to let your patent attorney know about that and know what date it was filed, because with the provisional patent application, you have up to 1 year to take action in terms of filing a regular application. So you don't want to miss that date. Now, if you have any questions about provisional patent applications or about how to write up a description of your invention, I have episodes for that, and I'll put the episodes links for those episodes in the description for this video, so you can check that out if you need more information about how to do a write-up or information about how provisional patent applications work. Next, we want to talk about a few procedural issues. Of course, you'll want to get a cost estimate. Some patent attorneys work hourly, others quote a fixed rate based on the complexity of your invention. You'll want to talk about what kind of retainer requirements or payment schedules that the attorney may require. So typically there is a retainer required, so at least part of the money, if not all of the money, will be required up front. And so just make sure you understand how that works in your case. There's different fees. There's the fees for preparing it, and then there are the filing fees that are paid to the government. So there's two sets of fees that you'll have to pay. So be clear when you're talking to your patent attorney if the price they quote you includes the filing fees, or does that just include the preparation fees. So just make sure, however they price it out to you, that you understand if that price includes the filing fees or not. You want to think about technical expertise as well. If you have a technical invention, now if you have a simple invention, then most any patent attorney will be able to handle it. But if you have an invention that's electronic, you're going to want to have someone who understands electronics working on it. If you have a chemical invention, you want to have somebody with a good chemistry background working on it. So if you have a technical invention, you want someone who's got the technical expertise to handle it. So just make sure that if that's the case for you, that you talk to the patent attorney to make sure that either that person or the person in the firm who's going to be working on it has that expertise. You want to get a feel for the time frame for preparation. We already talked about the schedule constraints. You definitely want to bring that to the attention of your patent attorney. But even if you don't have a hard deadline, you still want the thing to be finished in due course. So typically, I think a realistic expectation is something like 8 to 10 weeks in general, although it can happen faster if it needs to. So you just want to make sure that it's you understand when you can expect it to be completed. You'll want to know who you're going to be working with. Is it the lead attorney, or is it perhaps another associate? You just want to understand who are you going to be discussing the invention with. At some point, if you decide to proceed, the attorney will probably ask you to sign what's called an engagement letter to get the ball rolling, and that's where you will probably have to come up with the retainer as well. In general, NDAs, non-disclosure agreements, are generally discouraged. Some inventors, particularly independent inventors, often ask attorneys to sign NDAs. Many of them won't, some might, but it's generally discouraged. My experience is that patent attorneys are not in the business of stealing your idea, so that would be very unusual. But in any case, you may experience some resistance if you ask an attorney to sign an NDA. In general, if you're really concerned about this, you may be better off filing a provisional on your own first if you don't feel comfortable even talking to a patent attorney without having some sort of protection. But I think in general, you can trust that a patent attorney is not going to try to steal your idea. Now, you've heard me talking about patent attorneys, but there's another field of people that can help, and this is patent agents. Not everybody has heard of patent agents, but in the United States, patent agents are authorized to represent inventors before the U.S. Patent Office, and they can file patent applications on behalf of inventors. They're typically people with technical training, such as science or engineering degrees, that have also taken what's called informally the patent bar, or the test to basically certify them to practice a very narrow form of law in front of the patent office. So they can file responses to the office actions to move your application along. Why do people use patent agents? Well, because patent law is so specialized, the U.S. Patent Office opens up the field to some non-attorneys for the specific instances of filing patent applications. So the patent agents a lot of times have lower fees than attorneys, but they are generally not authorized to practice any other areas of law, such as contracts or things like that. But you may want to consider a patent agent because some of them are very good and also very technically proficient in their respective fields. So in summary, here are some tips for success for preparing to meet with a patent attorney. Be organized, be informed, and if you do that and you have all these things that we talked about, you're going to be presenting yourself as a serious client and hopefully establish a good relationship with your patent attorney and have a good quality patent application filed on your behalf. So hopefully this helps you in your endeavors. So thanks again for checking out this episode, and we'll see you again next time. Thanks.